Good morning, everyone. I am Nicole Guzman, the reporter of Republic Act 3019. Republic Act number 3019 Anti-Graft and Corrupt Practices Act. In Section 1, Statement of Policy. It is the policy of the Philippine government in line with the principle that a public office is a public trust. In Section 2, Definition of Terms. As used in this act, the term government, public officer, receiving any gift, and person. In Section 3, corrupt practices of public officers. In addition to acts or omissions of public officers already penalized by existing law, the following shall constitute corrupt practices of any public officer and hereby declared to be unlawful. First, persuading, inducing, or influencing another public officer to perform an act constituting a violation of rules and regulations, duly promulgated by competent authority or an offense in connection with the official duties of the latter. Next, directly or indirectly requesting or receiving any gift, present, share, percentage, or benefit for himself or for any other person. As directly or indirectly requesting or receiving any gift, present, or other pecuniary or material benefit for himself or for another from any person for whom the public officer in any manner or capacity has secured or obtained or will secure or obtain any government permit or license in consideration for the help given or to be given. In Section 4, Provision on Private Individuals. It shall be unlawful for any person having family or close personal relation with any public official to capitalize or exploit or take advantage of such family or close personal relation by directly or indirectly. In Section 5, Provision on certain relatives. It shall be unlawful for the spouse or for any relative by consanguinity or affinity within the third civil degree of the President of the Philippines, the Vice President of the Philippines, the President of the Senate, or the Speaker of the House of Representatives to intervene, directly or indirectly, in any business transaction, contract of application with the government. In Section 4, Provision on Members of Congress. It shall be unlawful hereafter for any member of the Congress, during the term for which he has been elected, to acquire or receive any personal pecuniary interest in any specific business enterprise which will be directly and particularly favored or benefited by any law or resolution authored by him, previously approved or adopted by the Congress during the same term. Section 7. Statement of Assets and Liabilities. Every public officer, within 30 days after the approval of this Act or after assuming office, and within the month of January of every other year thereafter, as well as upon the expiration of his term of office, or upon his resignation or separation from office, shall prepare and file with the office of the corresponding department head, or in the case of the head of department or chief, an independent office with the office of the president, or in the case members of the Congress and the officials and employees. In Section 8, dismissal due to unexplained wealth. If in accordance with the provisions of Republic Act numbered 1379, a public official has been found to have acquired during his incumbency, whether in his name or in the name of the persons, an amount of property and or money manifestly out of proportion to his salary and to his other lawful income, the fact shall be a ground for dismissal or removal. In Section 9, penalties for violation. Any public officer or private person committing any of the unlawful acts or omissions enumerated in Sections 3, 4, 5, and 6 of this Act shall be punished with imprisonment for not less than 1 year nor more than 10 years. perpetual disqualification from public office, and confiscation of forfeiture in favor of the government of any prohibited interest and explained wealth manifestly out of proportion to his salary and other lawful income. In Section 10, competent court. Until otherwise provided by law, all prosecutions under this Act shall be within the original jurisdiction of the proper court of first instance. Section 11. Prescription of offences. All offences punishable under this Act shall prescribe in 10 years. In Section 12. Termination of office. No, no public officer shall be allowed to resign or retire pending an investigation, criminal or administrative, or pending a prosecution against him for any offense under this Act or under the provisions of the revised penal code on bribery. Section 13. Suspension and loss of benefits. Any public officer against whom any criminal prosecution under a valid information under this Act or under the provisions of the revised penal code on bribery is pending in court shall be suspended from office. In Section 14, exception. Unsolicited gifts or presents or small or insignificant value offered or given as a mere ordinary token of gratitude or friendship according to local customs or usage shall be excepted from the provision of this Act. Nothing in this Act shall be interpreted to prejudice, or prohibit the practice of any profession, lawful trade or occupation by any private person or by any public officer who under the law may legitimately practice his profession, trade, or occupation during his incumbency except where the practice of such profession, trade, or occupation involves conspiracy with any other person or public official to commit any of the violence penalized in this Act. Section 15. Separability Clause. If any provision of this Act or the application of such provision to any person or circumstances is declared invalid, the remainder of the Act or the application of such provision to other persons or circumstances shall not be affected by such declaration. Unless Section 16. Effectivity. This Act shall take effect on its approval, but for the purpose of determining unexplained wealth or property acquired by a public officer since he assumed office shall be taken into consideration. That's all.